So I want to start by saying a huge thank you for having me here today. It's really such a privilege to be speaking to such a distinguished group of policymakers, lawmakers, litigators, technologists. And I've learned a lot from the sessions and from the talks myself, and I think it's safe to say that a lot of people in this room have expertise on the topics I'll be talking about. So I'm very interested, and hopefully we'll have some time for questions at the end. The question of how we detect and address discrimination in AI systems is not merely academic. I think it's one of the defining legal and ethical challenges of our time. And how we deal with this will shape whether AI is a force for good or something that entrenches existing inequalities in our societies. So my talk today has three parts. First, I'm going to provide a practical grounding in what algorithmic discrimination looks like in a legal sense. Secondly, I'll explain how the EU law framework maps onto algorithmic discrimination, and this is something we also discussed in one of our parallel sessions earlier. And third, I'm going to think about enforcement. How can we actually detect and prove that there is discrimination, unlawful discrimination, in algorithmic systems? So, what is algorithmic discrimination? When we talk about AI, we are usually talking about machine learning systems. And I think it's safe to say that these are systems which use the past to predict the present or the future. And of course, this creates a fundamental vulnerability, because if the historic data reflects bias, then the algorithm will learn that bias and reproduce it, because the algorithm is holding up a mirror to our past decision-making systems, and the reflection is not always that pretty. Consider a concrete example. Let's say an employer feeds into an algorithm a set of previous resumes, and it tells the algorithm which of these candidates was successful in the past. What if the successful candidates were disproportionately of a particular gender or a particular ethnicity? The algorithm doesn't distinguish between what features in the resumes are genuine competence indicators and which are artifacts of historical bias. And that's because it's not its job. It's just trying to replicate the human decision-making process. And what makes this particularly insidious is that the bias can creep in unexpected ways. The system may not explicitly consider gender or race or disability because the developers have stopped it from doing that, but it might learn to predict success for applicants who use certain patterns of language, certain types of verb, certain formatting choices that disproportionately appear in the applications of men or of people from a certain ethnicity, for example. And let me give you a concrete example of this. And I have on the slide here 4 screenshots from different examples of real-world bias that I'm going to go through now. The first is Amazon's hiring algorithm. I think a lot of people in the room already know about this example. It's a few years old now. But in a nutshell, Amazon developed an algorithm to try to screen applicants for its software engineering roles. And the system was trained on the resumes of the previously successful applicants. In fact, it's almost exactly the example I was just describing. And what the algorithm did in this case, among many other things, was it identified that applicants who used active verbs, so words like captured or I executed this, those applicants were more likely to get the job. But it was also the case that those kinds of words were more often used by men, whereas women would use more passive language. And Amazon eventually just had to abandon this system entirely because they couldn't completely get rid of these proxies. The second example I wanted to give was HireView's facial analysis. So HireView is a company which provides automated video interview software to employers worldwide. And it actually got rid of its facial expression analysis function in its algorithm because of concerns that that function was discriminating against people of particular ethnicities. Now, that was a voluntary decision by HireVue. It actually had some bias auditing, algorithmic auditing, that fed into that decision, but it does illustrate the kind of reputational and possibly legal risks that these kinds of companies are dealing with. The third example here is Meta's discriminatory housing advertisements. So this is from 2022 in the US. Meta had a settlement agreement with the US Department of Justice because of allegations that its lookalike audience advertising feature was discriminatory. Essentially, this feature allowed advertisers to choose audiences for their adverts who looked like a selected audience. But those audiences were defined partly using protected characteristics, like race, religion, and sex. So Meta had to stop using that algorithm entirely. And the final example here is facial recognition technology in policing. I'm coming from the UK, and this is something that has been particularly prominent in the UK recently, because as many of us know, studies have shown that facial recognition systems can have lower success rates for people with darker skin. And of course, if those systems are used by a police force, the consequences could be very extreme in terms of wrongful arrest, etc. But this case was actually the subject of a past lawsuit in the UK. The Welsh police in the UK actually had to stop using a facial recognition system in their policing because they had failed to adequately consider the risk of bias. Now, that was all the way back in 2019. The UK government now says that the facial recognition technologies have been improved and they don't have these problems anymore. But of course, this is an issue that's giving rise to some controversy. So I'm sure that there will be future questions about this moving forward. So that's the reality of what's happening in the real world. I want to now look at the legal framework. And the focus of my talk is going to be on equality law as it's developed over the decades in the EU. But before I get on to substantive equality law, I should just note that, of course, the regulatory landscape has shifted dramatically since this topic first arrived on the policy agenda. We now have the EU AI Act, the world's first comprehensive AI regulation. I only want to say a few very short things about that. First of all, there are prohibited AI practices. For example, certain forms of biometric categorization, social scoring, and these are possibly some of the situations in which AI discrimination could have the worst effects. Secondly, the AI Act, as we know, takes a risk-based approach. So, for example, AI systems used in employment, where discrimination risks are quite high, are classified as high risk, and there are certain obligations, as we know, that come along with that. And thirdly, and critically, Article 10.5 of the AI Act does now permit the processing of what under data protection law are special categories of data. So that includes, for example, race-related data for the purpose of bias detection and correction in high-risk AI systems. And this had been a serious tension between equality law and the GDPR because it wasn't so possible to use, for example, race data to correct for bias. But that has now been improved by the AI Act, although I think there is still some uncertainty in terms of the interaction between the two regimes. But the critical point I want to make here is that the AI Act and the various steps that have to be taken are really a floor for developers, not a ceiling. And in particular, compliance with the procedural steps in the AI Act will not necessarily give rise to compliance with substantive EU equality law. And I think the reality is that the foundation for challenging AI discrimination in the future is likely to be existing equality law. The key instruments in this area include various directives like the Racial Equality Directive, the Employment Equality Directive, the Gender Equality Directive. And as we discussed in one of the parallel sessions earlier, these directives prohibit direct discrimination, treating someone less favorably because of a protected characteristic, and indirect discrimination, which is applying an apparently neutral provision, criterion, or practice. In the UK, we refer to it as a PCP, which puts people with a protected characteristic at a particular disadvantage. These definitions of direct and indirect discrimination are broadly consistent across the directives, What I have on the screen at the moment is the text from the Gender Equality Directive, but the other directives follow broadly the same pattern. And these equality directives apply across a wide range of contexts: employment, social protection and social advantages, education, certain public goods like housing as well. And most of the academic literature on AI discrimination has focused on indirect discrimination, which is this concept of a PCP putting a group at a particular disadvantage. And I think that makes sense. The concept of an algorithm being an apparently neutral provision, which is putting people at a disadvantage, intuitively makes sense. We can generally understand how an algorithm might look facially neutral. I'm selecting the best candidates, but in reality, it ends up putting women, people with disabilities, particularly ethnic minorities, at a disadvantage. And the way it works under indirect discrimination law is that once you've shown that there are facts making that out, the burden shifts to the employer to justify the use. So this is where the need to identify discrimination arises. The question that anyone who's deploying an AI system should be asking is, does this system put a protected group at a disadvantage? Does it put women, people with disabilities, people of certain ethnicities, men as well, at any particular disadvantage? And that's the kind of analysis that needs to be done. Let me give an example. Say an employer adopts a system for customer service workers which records their calls and gives them scores, how friendly they are, how helpful they are. And those scores are then used to identify who should be promoted, who should get a bonus. But now imagine that whoever listened to the existing calls and trained the algorithm to identify the most helpful, the most friendly employees had some implicit biases, and they unconsciously ranked a specific protected group of people at a lower level than other groups. Now, the algorithm will, of course, learn that pattern. So a particular group's customer service ratings will be higher than the others. And if the employee could establish that they had been disadvantaged as a result, for example, they hadn't got a bonus, they would be able to then say to their employer, this is prima facie discrimination. And under indirect discrimination law, what would then happen is that the employer would have to justify why they used it. And what's interesting is that under EU law, the fact that you're saving costs is generally not enough by itself to show that the use is justified. But the employer might say, for example, well, I'm using this algorithm because it helps me to identify who are the best employees, and it's accurate in identifying the best employees. The focus will then shift to whether that's a proportionate approach. The algorithm must be a suitable means of achieving a legitimate aim, and its use must be necessary. So that means it must be the least discriminatory option available with this kind of level of accuracy. And I want to emphasize 3 points here. The first is that this means that if there is an equally effective but less discriminatory option on the market, the employer should be using that option. The fact that the other option is cheaper won't afford a defense generally under EU law. The second is that the algorithm must actually be achieving its aim, so it must be an appropriate means of identifying the best employees. Now, if this algorithm is actually identifying points that are irrelevant to competence, then it may well not be an appropriate means of achieving the aim. And thirdly, I think what will be very interesting in future cases to see is that if the algorithm is discriminatory, it might still be less discriminatory than the humans who previously made decisions about bonuses and promotions. So for example, even if a particular group is getting less bonuses than others, it might still be an improvement on the old human processes. And this question, I think, will arise as to whether it's proportionate for an employer to use the algorithm in those circumstances, even though in some sense that is entrenching bias. So that's indirect discrimination. Most commentary does focus on indirect discrimination. As I said, it's intuitive. But I just wanted to also flag that direct discrimination is possible. And this is critical because while the indirect discrimination framework permits the employer to justify the use, if it can be shown that there's direct discrimination, so there is a decision made on grounds of a protected characteristic, there's no opportunity for the employer to bring forward these justifications. And under EU law, there's no requirement for an employer or a public sector service or any other deployer of an AI system to actually intend to discriminate. Direct discrimination can arise without subjective intentionality. So for example, to take a basic example, if an algorithm was downgrading people who are pregnant, that could still be direct sex discrimination. Now, pregnancy is separately protected, but that was from very early EU case law. So direct discrimination is not impossible. And in some previous papers, myself and my colleagues argued that even if the algorithm is automating subjective bias, so the example of the customer service workers I gave earlier, that could potentially also be understood as direct discrimination, because if that was a manager, we'd probably think about that as direct discrimination. And I just pull up those papers. I don't want to discuss it in too much detail, because it could be a whole talk in itself. But if you're interested, I'm more than happy to send the papers that we wrote on this. But in the little bit of time I have left, I really want to talk about enforcement. Because when it comes to the challenges of detecting and addressing AI as a litigator, as a lawyer, the critical point I want to leave you with is this. For those who are affected by discriminatory automated decision-making systems, the primary obstacle I've found to addressing algorithmic discrimination is not actually the substantive law. It is getting the evidence to bring the case. Because EU equality law, as I've just described, is remarkably adaptable to these new worlds, these new systems, and it's very well developed. We've seen that the doctrines of direct and indirect discrimination can apply, and we don't need to reinvent the wheel. But the law only works if people can bring cases, and bringing cases requires evidence. In order to get a case off the ground, a claimant will need facts from which they can infer that discrimination has occurred. And think about our example with the customer service workers. How would an employee who has missed out on a bonus even know that discrimination is possible? They see their own score. They might have some informal conversations with their colleagues that identify that most of the people who've got promotions are men, for example. But how will they get the evidence to actually bring a case before the court? And I want to share with you two cases that I think illustrate the possibilities, but also the challenges of enforcement in this area. And I just have two screenshots again here on the screen. The first case is the Workday case. And I think this is perhaps the most significant development in AI discrimination litigation globally. It's from the US, where a man called Derek Mobley, who's a black man over the age of 40 who has certain disabilities, sued Workday, a major HR software platform, alleging that its AI job applicant screening tools systematically excluded him. And he had applied for over 100 jobs through the Workday platform, and he was rejected every time, often within minutes or hours, sometimes in the middle of the night. And he inferred that even though he'd met all these criteria, there must be something discriminatory going on an automated basis. Now, in May of last year, the court in the US granted preliminary certification of a US nationwide collective action under US discrimination law. And that collective action includes all of the individuals aged 40 and over who applied for jobs through Workday since September 2020 and who were denied employment recommendations. So the scale of this case is pretty staggering. Workday represented in its court filings that 1.1 billion applicants were rejected during this period. So the US collective could potentially include hundreds of millions of members. But in order to get that case off the ground, Mr. Mobley had to apply for these hundreds of jobs using Workday. And there are many cases where the applicant, in any situation, just can't make that kind of analysis. So for example, if you're applying for public housing or for benefits, you might just have one shot. So how are you going to gather the evidence to show systematic exclusion? The second example is also from the US, and it's about a healthcare algorithm. And this comes from a landmark 2019 academic study, which revealed systematic racial bias in an algorithm developed by Optum, which is a subsidiary of a US healthcare group. And it was used across the US to identify high-risk patients who would benefit from additional healthcare resources. And the algorithm affected approximately 200 million patients annually. The problem with this algorithm was that it used healthcare costs as a proxy, as a way of predicting healthcare needs. But because black patients in the US had historically spent less money on their healthcare due to barriers to access and systematic inequalities, the algorithmic system falsely concluded that they were generally healthier than patients of other ethnic groups. So, for example, the study found that black patients were assigned the same risk score as a white person who was actually quite a lot healthier than them. And critically, this algorithm, again, did not include race as a variable. The developers hadn't included any kind of explicit racial bias. It was ostensibly race-blind, but it had these proxies built in. Now, this case prompted regulatory action in the US, but again, the patients would never have been in a position to just bring this case. The way the researchers found out about this was because certain hospitals that were deploying this system provided de-identified patient data to this academic research group so that they could do this research. But from the position of a patient who's been denied healthcare, how do you actually bring a case to the court? And so my own view is that if equality law is to be reformed to deal with AI, I think the focus really needs to be on making these systems transparent. And again, we're not starting from scratch here in the EU, because in addition to a very well-established equality law framework, in the EU we also have one of the most robust data protection frameworks in the world. I'll just highlight two provisions of the GDPR, which I have on the screen right now. The first is Article 22, which provides that in the limited cases where automated decision-making systems can be used, suitable safeguards have to be in place. And those safeguards could well include disclosure of disparate impacts moving forward. And secondly, Article 15(1)(h) of the GDPR requires meaningful information about the logic involved in these kind of automated decision-making systems. And the Court of Justice has interpreted this to mean information that enables the data subject to actually be in a position to challenge the decision. And I think moving forward, the courts should consider whether this has to also include information about possible disparate impact. So I want to close with a few recommendations. First, for policymakers, I think the first one is prioritize transparency. The substantive framework is largely there. What we need are the tools to actually make it work. Secondly, empower equality bodies to look into these matters. They need the resources, the technical expertise, and the clear mandate to investigate algorithmic discrimination, because individuals can't do it by themselves. And thirdly, we need to continue clarifying the interplay between the AI Act and the GDPR to make sure that data protection law doesn't stand in the way of debiasing, but at the same time protecting people's rights. And finally, for the developers who are in the room, a similar set of recommendations. I think it's critical that we design not only for debiasing, but also for transparency, that we audit for bias continuously, not just on a one-off basis, and that we maintain human oversight of all of the decisions. So I think that's everything I have to say. We have a couple of minutes left, so if we have any questions in the room or contributions as well, I would love to hear them.
Thank you, Aislinn. You can just raise your hand, and if you have a question, you will get the mic. Is there any questions? Everyone are very shy. I will then ask myself, you gave some examples from the US, but what about if these cases would have happened in Europe? The law is different. How successful these would have been here?
Yes, so I did give a couple of US examples because I think they're the ones that have gone to court more. There is a really good report by the Council of Europe written by Raffaele Zenidis. I know one of the colleagues from the Council of Europe is here who will be able to say more about it. But in that report, there are a lot of examples of instances in the EU of possibly biased algorithms being used. I think if these two examples had arisen, the Workday example, which probably did affect some EU people as well, or the healthcare algorithm example, certainly we would have been able to bring a challenge under EU law, under either direct or indirect discrimination law. But the problem, of course, would have been actually bringing the case before the court. And at the moment, I think where we're maybe finding more of a challenge compared with the US is we don't have so many mechanisms for collective actions. It's increasing now with the directive, particularly in the data protection space, but I think in the equality space, if we have more scope for collective actions, that could potentially help.
Do you have some examples from the EU where these legal cases have been successful, that people actually have gone to court and been there successful?
Yeah, so there haven't been so many examples, but I can give one from the UK. So this is under EU law, of course. I think it actually maybe started pre-Brexit, but has now concluded. So this one was by an Uber driver. So Uber has a system where to start driving on your session, you have to use the facial recognition technology system to log into the app. And essentially there was a black man in London who tried to log in multiple times, but unfortunately he kept on getting denied because the facial recognition technology did not recognize him. And he brought a case supported by the equality body in the UK and also by his trade union to say, this is discrimination because there's all this academic research that shows that facial recognition technology can be biased. And Uber tried to get that case thrown out of court in the UK. They did not succeed. The court said, we're going to have the trial about this. We think there's a possible case of discrimination here. But actually what then happened before the trial began, it was meant to start at the end of last year, Uber settled the case, and I think possibly they didn't want to create a precedent. So this is one example. That would have been one of the first examples under kind of EU equality law, I think. But I'm also curious to hear whether there are some domestic examples that maybe haven't reached me in the UK that I haven't heard about. Maybe some people in the room can share. I was asking our colleague at the Council of Europe earlier, and he did mention there are some decisions by equality bodies, but maybe not so much court litigation.
Thank you. Let's give a round of applause for Aislinn.